22 in case number 23CR 397, State of Ohio versus Alexandria Fort Queen. Your Honor, the defendant is present today represented by counsel Justin Kerr. We are set today for sentencing. The state has had the opportunity to review the pre-sentence report as well as the drug and alcohol report put together by Dr. Rinsberg and is prepared to proceed today. Thank you, Your Honor. I do believe there's a joint recommendation for community-controlled sanctions. However, the specific terms of those conditions are not in agreement.
Thank you. Give me 1 second. Mr. Kerr, any reason not to go forward with sentencing on both of these cases at this time?
No reason, Your Honor.
Is there anything you would like to say at this time on behalf of your client?
Yes, Your Honor. We would ask the court follow the recommendations in the pre-sentence report prepared by Dr. Rinsberg. Prior to this case, Ms. Fort Queen has no felony convictions. She has already served 100 days in jail. She has every reason to want to come back from this. She has a great family that's here supporting her today throughout her struggles. She has 2 children, one of whom is playing cornerback for the University of Wisconsin. I'd also like to bring to the court's attention in Dr. Rinsberg's report a couple of things. First is that it notes that she has strong mental health. I think this gives her a better chance to come back than if she suffered from mental health issues. I'd also like to point out that the doctor found her to be very forthcoming throughout the process, and I have found her to be very forthcoming as well. She's acknowledged that she has made mistakes. She's made considerable mistakes. But if there's one thing I'm certain of, it's that if you're lying to yourself, you're never going to make it. Ms. Forquarian has owned her problems, and I hope that this case today can be part of the beginning of her comeback story. Her family looks forward to her writing the next chapter very soon.
Thank you. Ms. Fort Queen, you have the right to address this court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Your Honor, thank you for giving me this opportunity to address the court. I take full responsibility for my actions. Your Honor, there is no punishment that you could meter out that would be worse than the shame, guilt, and regret that I have endured due to my actions that has brought me before you today. There is no excuse that would justify using, and I want to apologize to my parents for the added stress I have contributed to their life when they have suffered the loss of my sister, their daughter. Reflecting back on the circumstances, I see how non-caring I was to believe I was suffering alone. I also want to thank my parents for their unconditional support, which has shown me I'm not alone, and throughout this ordeal, it has strengthened not only our relationship, but their forgiveness has allowed me to forgive myself. Your Honor, I acknowledge there are consequences for my behavior. Since my incarceration, I've utilized the institution's self-help programs that will help assist me with coping skills, so I can be a productive citizen again. Your Honor, I am not a bad person. I made bad decisions I have truly learned from. Again, I thank you for your time and most of all, your consideration.
Thank you.
Your Honor, if I may be heard just briefly, I understand and completely appreciate that the court does have obviously valid concerns about Ms. Forquarian's follow-through on a variety of issues. But I would ask the court to consider that any time she didn't follow through was when she was using. The one thing we can be certain of is she has been clean for 100 days, and if she completes the jail treatment program, then we'll be approaching 130 to 150 days. And this gives her a chance to get a fresh start and to make better decisions from a point of sobriety as opposed to the failures of an addict. And I hope the court will consider that and follow Dr. Rinsberg's suggestion was that she complete 12-step programs after she completes the jail treatment program, continue to do counseling, and maintain full-time employment. She intends to do so, and we just hope that the court will allow her to move on.
Thank you. State of Ohio.
Thank you, Your Honor. Your Honor, as I said at the outset, the state's in agreement with the community control sanctions in this case.
Speak up a little bit.
Yes, Your Honor. State's in agreement with community control sanctions. However, where we differ is the recommendations on those community control sanctions. Your Honor, these cases began, as the court's aware, initially as a single case with an information, with an opportunity for her to complete an intervention in lieu, essentially not even have these cases on her record going forward. Rather than complete even a inpatient assessment on that case, she chose not to do that, chose to ignore the request of the court, the request of probation to come in and meet with her, and complete what, at that time, Judge, probably would have been a request for her to complete JTP and do some counseling outside. She didn't do that. Instead, she chose to ignore the orders of the court, ignore the warrant that was out for her arrest for close to a year. When she comes back to Ohio and she's back in town, she picks up another case, again, drug possession, and now an OVI. Because of those reasons, Your Honor, I think something more than just simply doing JTP and being released is appropriate. We would ask that in addition to JTP, she complete the NeoCap program, where we know she's going to go to that program. We know it'll be completed. It's not going to be on her terms. It'll be on the court's terms and the state's terms, and we would ask that be done today. Thank you.
Thank you. Court has reviewed the pre-sentence report investigation, Dr. Rinsberg drug and alcohol assessment. I have considered the facts and circumstances of each of the two cases that we are here for this morning, the nature of those offenses, which are pretty much identical. I've considered what's been said here today in open court by Mr. Kerr on behalf of his client, Ms. Forqueen herself, prosecutor's comments, the recommendations from all the parties. All of this is being considered by the court in light of the purposes and principles of felony sentencing, which are set forth in 2911 of the revised code. As for the factors in 2912, factors indicating the conduct is more or less serious, the court does note under the seriousness factors that in each of these two cases, they're almost identical, the defendant was operating a vehicle. She was found behind the wheel of a vehicle, passed out, under the influence. And obviously, I don't think it's well, maybe I think it's obvious, but regardless, that makes it more serious to me that a person is possessing drugs, actively using the drugs, and operating a vehicle and putting others at risk at the time. That makes it more serious. Nothing makes it less serious. As for recidivism factors, there is a history of criminal convictions. These are her first felonies. The prior convictions had been misdemeanor offenses. But multiple convictions in the past, going back to 2015, for possession of drugs, theft, falsification, petty theft, disorderly conduct, and the offenses start here with these charges. The court does note that the offense committed in 23 CR 397 was committed when she was on bond to this court in 22 CR 1032, when she was also on probation to the Mentor Municipal Court in their case, 22 CRB 0600667 A and B. So in the first case, 22 case, she was committed in March. She didn't get charged immediately. Meanwhile, then, she picks up another charge at a Mentor. It's put on probation. Our case is pending, the 22 case, where her lawyers had filed a motion to get intervention in lieu of conviction, which was unopposed at the time. When she was contacted by the probation department to come in for her assessment, she said, "I'm not coming. I'll be there for my court date." So she didn't even show up for an assessment. Then she didn't show up for her court date. She left the state of Ohio. All of these are violations of her bond. She gets arrested a year later under the exact same circumstances which led to her arrest in the first case, being found behind the wheel of a car, drugs. There are multiple bond violations, which is also a factor indicating recidivism is more likely. And a drug abuse problem that relates to the offense and hasn't done anything to address it. In fact, was given an opportunity to address it again with treatment in lieu and just blew that off. No factors indicate recidivism is less likely. Under 2913B1, the court finds that in case 23 CR 397, again, she was on bond to this court and on probation at the time she committed the offense. That overrides any presumption for probation, permits the court to impose a prison sentence without having to make any findings to overcome any presumptions. Despite that, and defendant's conduct in this case leading up to this point, the court finds at this time that prison would not be consistent with the purposes and principles of sentencing, and the defendant would be amenable to an available community control sanction. So in both of these cases, I'm going to place the defendant on community control sanctions for a period of 2 years. Now, I understand you've been in jail for 100 days so far, but that's all on you. I mean, in this case, you were out on bond. The only reason you are in jail is because you failed to appear for your court dates. So you were out on a bond in this case, and you got arrested because you failed to appear. Plus, you're serving a sentence out of the Mentor Municipal Court of almost 6 months. You've been serving that this whole time. So I appreciate that you've been in for 100 days, but I'm not going to minimize or change the sentence that I think should be imposed in this case because of the fact that you have 100 days of credit when, quite frankly, that's for another case that's not completely unrelated to this case. So I'm going to order as conditioned, this is for both cases. 2 years community control sanctions. I'm going to order that you serve 90 days in Lake County Jail. You have 2 days credit. But I'm going to order that you immediately get into, as soon as possible, the jail treatment program. As soon as you've completed that program, I am going to order that you enter either Oak House or Nevaeh Ridge and participate in that treatment center there, the treatment facility. As soon as the bed's available, you can be released from the jail after you've successfully completed JTP. The rest of the 90 days will be vacated. You won't have to do that. Successfully complete either Oak House or Nevaeh Ridge, whichever has the bed first. Follow their aftercare recommendations. The other conditions are going to be as follows. You're not to use any drugs or alcohol. You have to submit random urine screens when requested. They have to be negative. A positive screen's a violation. You can't screw around with your urine samples or bring in fake urine or bring in someone else's urine or anything like that. To me, that's worse than testing positive, to be honest with you. Now, obviously, I know you're serving a sentence right now, which isn't up until October. That's got to get addressed. Your lawyer has indicated he believes that will be addressed, but I can't trump that. If that doesn't get changed, you have to stay in until October. You understand that? I can't, my order, I don't have the power to vacate their sentence and let you out early. So that's something that has to be addressed, taken care of, which Mr. Kerr has indicated he believes he'll be able to do that, or at least attempt to do that. But I can't do that. I want you to attend 3A meetings a week and have a sponsor. You're to obtain and maintain full-time employment or education. If you want to go back to school or get some type of training, you can do that as well. But on a full-time basis, I want you either working, going to some type of school, or a combination of the two part-time to keep yourself busy full-time. Pay your court costs and supervision fees. I you to get a mental health assessment and attend some counseling, brief counseling type of stuff to address the issues that, at least you've indicated, you believe caused you to do what's happened here. I know that you have your sister, you have your husband. You've never dealt with that, it doesn't seem like, at least the proper way. So I want you to get some outpatient therapy counseling to deal with that as well. Since both of these cases involved... What's that?
I'm sorry, Your Honor.
Since both of these cases involved her operating a vehicle at the time, suspended defendant's driver's license for 1 year. That covers everything. Anything else you can think of? I'm going to order that you have one doctor and one dentist that can prescribe you medication. If you have a specialist, that's fine as well too. But any doctors that give you prescriptions for medication, probation needs to know who they are. You can only have one pharmacy where you get those filled, and they need to know where that is as well. There is the OVI in the one case. Hang on a second here. Mandatory fine there.
$375, Judge.
Okay, in case 23 CR 397, mandatory fine required for count 2, $375 is the minimum. That's what it'll be. Her license is suspended for 1 year on that as well, but the suspensions are all concurrent suspensions. That's mandatory. I have no choice there. In that case, have the entry read it's the 90 days. Actually, 90 days on count 1, just do the 3 days on count 2 for the OVI, which is, those are concurrent. Understand that?
See, 90 days on count 1 and 2 days on count 2?
3,
3.
which is the minimum, which is she's required to do. Concurrent with each other. Can you understand all the conditions of your community control sanctions?
Yes.
Any questions?
No.
You need to talk to the microphone.
No.
Thank you.
I didn't know there was one there.
I need to advise you if you fail to comply with any of the conditions of your probation, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, a motion to terminate your probation will be filed. If it's found that you did violate, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that in case 22 CR 1032, it would be 12 months on each count consecutive for 2 years in prison. And in case 23 CR 397, it would be a period of 12 months on count 1. The 2 cases would be consecutive to each other, so there's 3 years of prison hanging over your head with both cases. Do you understand that?
Yes.
All right. Ms. Newman, can you get her on the list for those facilities right away?
Yes.
All right. Mr. Foyce, is there anything else for the record we need to discuss?
Judge, if you did not say it, just a forfeiture of all contraband, and you may have said it and I may have missed it.
I didn't say it, but there's no specifications that are...
Just ask that this time we're on order for a voluntary forfeiture of the heroin as well as
There's
the...
no specifications. I'm not addressing
Okay.
that. If voluntary. If it's voluntary, unless there's an agreement. Mr. Kerr, anything else?
No, nothing further, Your Honor.
Thank you.
Thank you, Your Honor. We're here today in two separate cases, both entitled State of Ohio versus Justin Umholtz. Those case numbers being 23 CR 000474 and 23 CR 000540. Defendant is present in open court today with his counsel, Mary Springer. Your Honor, in the 540 case, a one-count information was filed on June 14th of 2023. That one count being possession of cocaine, a felony of the 5th degree, with a forfeiture specification. In the 474 case, a one-count information was filed on June 15th of 2023. That one count being attempted robbery, a felony of the 4th degree. It's the state's understanding today that the defendant will waive his right to indictment in both cases and will plead guilty by way of information in each case to each count in those informations. We would then ask to defer sentencing so that a pre-sentence report, psychological, and victim impact statement may be ordered. And that's the state's understanding at this time.
No other discussions regarding recommendations which are part of the plea negotiations?
There's no notation from Ms. Linden that there was any sentencing agreement.
Thank you. Ms. Springer, does that all sound accurate?
Yes, it does, Your Honor.
And Mr. Umholtz, were you able to hear what the prosecutor and your attorney just indicated to the court as to what they believe your intentions are here today?
Yes, sir.
They indicated to the court, make sure you speak up. Move that microphone over a little bit.
Yes, Your Honor.
Make sure, you don't need to lean into it, just keep your voice up, that'll be good enough. It was indicated to the court they believe it's your desire in each of these cases to waive your right to have each case presented to a grand jury, and I'll explain in more detail here in a moment what that actually means. And then you're going to go ahead and plead guilty to the charges that are set forth in the information, which I will also review with you to make sure you understand what those are. We would then defer sentencing to get some evaluations completed, come back on a later day for sentencing where there's no agreement between the parties at this time regarding any recommendations. Each side is free to recommend to the court whatever sentence they believe would be the right thing to do. Is that your understanding of the discussions that have taken place between your lawyer and the prosecutor, most importantly what you want to do here at this time?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. Now, if at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you can ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Well, let's get started then here. Now, when I go over these rights with you and everything, they apply to both cases. If there's anything that specifically applies to one case and not the other, I'll make sure I point that out. I don't think that's going to be the case, but if it should, I'll let you know that. Otherwise, everything I'm telling you applies to both cases, all right?
Thank you.
All right. Well, let's get started then. How old are you, sir?
I'm sorry, Your Honor.
How old are you?
I am 43 years old, sir.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No, Your Honor.
What about within the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
Diabetes medicine, Your Honor.
Is that it?
Yes, Your Honor.
Yes. Did you receive a copy of the information that was filed in each of these two cases? That's the document that sets forth the specific charges you're accused of committing and pleading guilty to?
Yes, Your Honor.
Did you have a chance at some point to look those over and review them?
I did, sir.
Now, let's start with, I have up here 23 CR 540. You're charged with one count of possession of cocaine. And what's alleged here and what you'll be admitting to is on or about March 7th, 2023, in Wickliffe Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound, mixture, preparation, or substance containing cocaine. The amount involved did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to this count?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, there's also what's called a forfeiture specification that's a part of this charge, which alleges that during the commission of the offense, you possessed or had some interest in property that was considered to be contraband or an instrumentality. Contraband is property that's illegal just because of the nature of the property it's illegal. Whereas an instrumentality, it's some type of property that there may not be anything illegal about it, but it's being used in an illegal manner to facilitate an illegal act, and you can't use it for that purpose. And here it's alleged there's the cocaine itself, along with some oxycodone, some plastic baggies, and a plastic container. The whole point of the specification is that you forfeit any right you have to this property at the time of sentencing. You understand that?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, in the other case, 23 CR 474, again, you're charged with one count by way of information, and what's alleged here and what you're admitting to is on or about April 20th, 2023 in Eastlake, Lake County, Ohio, that you did with sufficient culpability for the commission of the offense of robbery, that you engaged in conduct if successful would constitute or result in the offense of robbery in violation of 2911.02A3. And let me make sure you understand what the robbery charge itself involves so that we can have a clearer understanding of what attempted robbery is. But robbery under 2911.02A3 prohibits any person in attempting or committing a theft offense or in fleeing immediately after committing or attempting to commit the theft offense from using or threatening the immediate use of force against another. So that conduct I just read to you constitutes the offense of robbery. You're going to be pleading guilty to engaging in conduct that, if successful, would have resulted in that offense. And the significance of the difference between the robbery itself and the attempted robbery is that the robbery is a felony of the third degree, whereas the attempted robbery is a felony of the fourth degree, which is less serious. And there's a big difference between a felony of the third and fourth degree. So you'd be pleading guilty to attempted robbery, a felony of the fourth degree. So do you understand what you're charged with and what you're ultimately pleading guilty to?
Yes, Your Honor.
Any questions about it for me?
No, Your Honor.
Well, then before I can accept your guilty plea in either of these cases, I need to make sure you understand all the rights you're giving up by pleading guilty. And in each of these cases, you first off have the right to have each case presented to a grand jury. So the charges I just read to you in each of these two cases are charges that are filed by way of an information. What an information is, it's a criminal charge brought by the prosecutor without the case previously having been reviewed by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together. They meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. We define probable cause as some evidence that would suggest the person probably committed this criminal offense. Everyone here in the state of Ohio accused of a felony has the right to have a grand jury independently review all the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged with a crime or not. You have that right as well. But you can give up or waive that right if you desire and go forward on the charges brought by the prosecutor in this information. And your attorney has indicated she believes that's what you want to do for both of these cases. Is that correct?
Yes, sir.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing. And I have in front of me at this time then two documents, one for each case, otherwise they're identical pretty much, which sets forth and explains what I just told you about the grand jury and that you want to give that up. Now, my understanding is before I came out here, you had a chance to look over both of those documents with your lawyer. Is that correct?
That's correct, sir.
Ms. Springer, is that accurate? Did you read these over with your client and review them with them, make sure he understands them?
Yes, I did, Your Honor.
Did he indicate an understanding of them to you?
Yes, he did.
Is that correct, Mr. Umholtz?
Yes, sir.
Do you have any questions for me about what any of those documents
No,
state?
sir.
And it looks like on both of them, you've signed both of them. Did you in fact sign them?
I did, sir.
Ms. Springer, did you witness that?
Yes, I did.
Ms. Kutchu as well?
Yes, Your Honor.
All right, well, each of those documents will be made part of the record at this time. At this point, Mr. Umholtz, I'm going to review with you all the other rights you have that you are giving up by pleading guilty. And you first of all have a right in both of these trials to have a trial. And that trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right in each of these cases to have a jury trial. And a jury trial will be in front of 12 citizens here from Lake County who will listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors will make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. What that means is all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial in either of these cases?
Yes, Your Honor.
Now, if we did have a trial in either case, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Now, by her having the burden of proof, what that actually means, it's her job, or she bears the responsibility or the obligation. She bears the burden of proving you guilty at a trial before you could ever be found guilty. You are presumed innocent of both of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when we speak of that burden of proof, since this is a criminal case, the burden is what we refer to as proof beyond a reasonable doubt, and that is the highest burden we have in our justice system. And what it really means, it's the amount of the evidence and the quality of the evidence the state has presented at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of each of the offenses beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
I do, Your Honor. Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to try to do that, if we were going to have a trial in either of these cases, the prosecutor here would be bringing witnesses in the court to testify for the state by answering questions from the prosecutor. Now, once these witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. She could ask him anything she wanted to within certain rules. Do you understand that?
I do, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court and testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that, but you have the right to do that if you wanted. Do you understand that?
Yes, I do.
And you further can request the court issue an order, and we call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to voluntarily come in on their own. Do you understand that?
I do, Your Honor.
And do you realize you're giving up that right?
Yes, sir.
You also have the right at trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's solely your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
You further understand that if we did go to trial and you were found guilty of either of these charges, you would have the right to appeal or challenge that guilty finding to a higher court that's above me. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. The court will enter if I accept your plea, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have in both of these cases and all the rights you're giving up by pleading guilty. Any questions?
Yes, sir.
You do have questions?
Oh, I'm sorry. I thought you asked me if I understood that. I do
I'm
not,
asking if you have
sir.
any questions regarding any of the rights we just talked about.
No, sir.
You understand them all?
Yes, sir.
You still want to plead guilty?
Yes, sir.
Now, do you understand your guilty plea in each of these cases would be a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or that's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
I do, Your Honor.
As far as sentencing goes, you're pleading guilty in case, let's start with 23 CR 474, that's the attempted robbery. It's a felony of the fourth degree. This offense carries with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
Now, in the other case, 23 CR 540, that's the cocaine charge. That's a felony of the 5th degree. That offense carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in the range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, since we have two separate cases here that are completely unrelated to each other, if I were to impose a prison sentence in each of these cases, as the judge, I have the discretion to run those sentences either concurrent or consecutive with each other. Concurrent to each other means you serve them together at the same time, the prison terms, whatever they are. Consecutive means one after the other. You'd serve the prison term in one case first, complete that, then serve the prison term in the second case. Do you understand the difference there?
Yes, sir.
Any questions about that?
No, sir.
So in these particular cases, with both cases together, you're looking at a possible maximum term in prison of 2.5 years. Do you understand that?
Yes, sir.
Now, are you currently on probation or post-release control or any supervision to any other courts or agencies?
No, sir.
Excuse me. Do you have any other charges currently pending against you right now?
No, sir.
If a prison sentence is imposed in either of these cases upon your release from prison, you could be placed in what we refer to as post-release control, sometimes called parole. What that is, it's a period of supervision you would be on after you serve the prison sentence. And it could be, in these cases, either of these cases, up to 2 years. Do you understand that?
Yes, sir.
And if you were on post-release control for either of these cases, you never violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. In the attempted robbery case, you could be fined up to $5,000. In the case of the possession of cocaine, you could be fined up to $2,500. Do you understand that?
Yes, Your
So
Honor.
with both cases together, there's a maximum total fine of $7,500. Both cases, you can also be ordered to pay court costs or reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
In the attempted robbery case, I'm not sure if it's applicable, but you could order to be paid restitution to any victim for any economic loss any victim may have suffered as a result of the conduct involved. Do you understand that?
Yes, Your Honor.
And in the cocaine case, there's a possible driver's license suspension that could be imposed of up to 5 years. Do you understand that?
Yes, Your Honor.
Also, for the cocaine charge, any right, title, or interest you have in any of that property I read off to you before as the contraband or instrumentalities, that would be forfeited to the state of Ohio at that time. You understand that?
Yes, sir.
Now, a few moments ago, I explained possible prison sentences you face by pleading guilty. When I did that, I used the word possible because prison is not mandatory in either of these cases. Each case, you are eligible for probation, or what we've formally referred to as community control sanctions. Do you understand that?
Yes, Your Honor.
Now, do you understand that just because you're eligible, that doesn't mean you'll automatically be put on probation? It means I'll consider that, if that's what you're requesting. I'll look at all the information that gets presented to the court, then I'll make the decision overall that I think is the right thing to do. Do you understand that?
Yes, Your Honor.
If you are put on probation in either of these cases, it could be for up to 5 years, and as the judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a time in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes, Your Honor.
Further, if you are on probation in the court and you're violating the conditions of your supervision, we'll have a hearing here in court to see if you're what's called a probation violator. And if it's determined that you are, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, again, it could be 6 to 18 months on the attempted robbery charge. It could be 6 to 12 months in the possession of cocaine charge. Those terms could be served consecutive to each other for an ultimate overall prison term of 2.5 years in prison. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right on that day. Say anything you want. Anything you'd like me to know or consider. Your lawyer can speak on your behalf. She can recommend the sentence to the court. The prosecutor here can also recommend the sentence to the court. Do you understand that?
I do, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
I do, Your Honor.
All right, well, do you have any questions at all about the rights we've just discussed? About the potential penalties that you face here by pleading guilty?
No, Your
You
Honor.
understand all the possible consequences that could occur at the time of sentencing?
I do, sir.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about these cases with your lawyer, have her review the reports with you, excuse me, discuss the issues and answer all your questions?
I have, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Has she, or has anyone for that matter, made you any promises about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering your plea freely and voluntarily?
Yes, Your Honor.
All right, then. Do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to talk with your lawyer before we go forward with the actual plea?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her and what she has to say, because I'm going to ask some follow-up questions for you, all right?
Yes, sir.
And let's do one case at a time, make it easier. I'll start with the cocaine charge. I guess chronologically that was first, so,
Yes, Your Honor, that's in 23 CR 540.
okay.
Had that matter proceeded to trial, the state would have proven beyond a reasonable doubt that on March 7th of 2023, around 5:10 p.m., Wickliffe Police Department officers were dispatched to the Tapestry Senior Living Center located on Euclid Avenue in Wickliffe, Lake County, Ohio, for a male in a vehicle in a parking lot, possibly using drugs. Lake County narcotics agents were in the area, heard the dispatch, went to the location, arriving there before Wickliffe Police Department officers. Narcotics agents saw the defendant with an orange syringe cap in his hand, using a napkin to wipe blood from his arm. The agents also saw a prescription bottle in the car with the defendant's name on it. It had a pink solid substance in it and a cotton swab as well. There was an uncapped syringe stuck in the driver's seat. There was a bag with syringes in the driver's sun visor, a black bag with more syringes, and pink pills. The pink solid substance was sent to Lake County Crime Lab and found to be 1.74 grams of cocaine and Schedule II controlled substance. The pills were found to be oxycodone pills, Schedule II controlled substance. All of this occurring in Lake County, Ohio, and that would have been the state's evidence on that matter.
Jerome Holtz, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show in case number 23 CR 540?
Yes, sir.
And what, if anything, do you have to say about those facts as she presented them? Are they true? Did you do as she said?
Mary,
He said, are they true? Did you do what she said?
yes, Your Honor.
Very well. Then regarding count one, charging with possession of cocaine, a felony to the 5th degree, along with the forfeiture specification. What is your plea to that?
I'm guilty, Your Honor.
All right, Ms. Cutts, if you could go ahead with the next case, please.
Thank you, Your Honor. In 23 CR 474, had that matter proceeded to trial, the state would have proven beyond a reasonable doubt that on April 20th of 2023, approximately 3:50 p.m., Eastlake Police Department officers were dispatched to the Drug Mart on Vine Street in Eastlake, Lake County, Ohio. Loss prevention officer indicated that the defendant, Justin Umholtz, who was later identified, was seen to be taking 2 items, hair care products, from the store. He did go to leave the store without paying for them. She did notice the defendant seemed to be a little off. She was concerned. He was overly sweaty. She went to the door to try and stop him. After he had passed all points of sale, he became physically combative, pushed her. She did fall to the ground with some redness on her hands and knees. The defendant was stopped by the store manager until police arrived. The items were recovered and restocked. The value was $33.98. All this occurring in Lake County, Ohio, and that would have been the state's evidence.
Mr. Umholtz, were you able to hear what the prosecutor just had to say regarding what she believes the evidence in this case would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about these facts as she presented them? Are these facts true as well? Did you do what she said?
Yes, Your Honor.
Very well. Regarding count 1, charging with attempted robbery, a felony of the 4th degree, what is your plea to that count?
Guilty, Your Honor.
All right, I have in my possession at this time 2 separate documents. Each of them are called a written plea of guilty and judgment entry, and each of them explain everything I've just gone over with you. Before I can accept your plea in either of these cases, I need to make sure you understand what's in these documents and that you sign them here in open court. Now, my understanding, again, is that before I came out here, you had a chance to go over these documents with your lawyer. Is that correct?
That is, Your Honor.
Ms. Springer, is that accurate? Did you read these both to your client and review them with him?
Yes, I did, Your Honor.
Did he indicate an understanding of them to you?
Yes, he did, Your Honor.
Is that correct, sir?
Yes, sir.
Any questions for me about what either document has to say?
No, Your Honor.
Now, it appears at the end of each of these documents that you signed each of them. Did you, in fact, sign them?
I did, Your Honor.
Ms. Springer, did you witness those signatures?
Yes, Your Honor.
Ms. Kutchu as well?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his attorney, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of all those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty plea, as well as the maximum penalty that can be imposed in each case. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. And in case 23 CR 540, find the defendant guilty of possession of cocaine, a felony of the 5th degree, in violation of 292511 of the revised code with the forfeiture specification. And in case 23 CR 474, I'll find the defendant guilty of count 1, attempted robbery, a felony of the 4th degree, in violation of 292302 and 2911.02A3. I will defer sentencing in each of these cases at this time. In each case, I'm going to order a pre-sentence report, drug and alcohol evaluation, psychological evaluation, and in case 23 CR 474, I'm also going to order a victim impact statement. My understanding is, in regards to bond, that in 23 CR 540 case, bond was previously revoked, so there is no bond. In the other case, I think it's 5,000, 10%. You wanted to be heard on the matter of bond, Ms. Springer?
Yes, Your Honor, thank you. The defense did previously file a written motion to modify bond last week on June 29th. Mr. Umholtz has a number of support systems that's working with him, including members of his family. His father is here today, as well as his fiance, and then a number of gentlemen who are veterans themselves and are helping to support Mr. Umholtz, who has also served our country. So for his substance use problems, they had reached out to a local treatment provider called Assurgent, ASURGENT Health, that's located in Cleveland Heights. They have an opportunity for him to complete a partial hospitalization program, as well as have sober living for him. The partial hospitalization program is between Monday and Friday, nearly 6 hours every day. If the court would give him the opportunity for an own recognizance bond, he is aware that it would be a condition of his bond that he have to remain at that facility and complete that program. He does have reliable transportation through his support systems, who would be able to pick him up at the jail, to drive him to treatment, as well as bring him back and forth for any meetings with probation and then his court hearings. Additionally, Mr. Umholtz does have a number of physical problems that he's hoping to attend to, a lot of which is related to his service. He has a back problem that he is hoping to see a specialist for, and he may need surgery for. So he has been in court. He has been located in the Lake County Jail since the date of the robbery offense, and is hoping that the court would give him this opportunity to get out on bond pending his sentencing hearing. He is also aware that if he did fail to appear for that he would be facing an additional charge of a felony failure to appear, and is aware of those penalties as well. Thank you, Your Honor.
He was on bond when he committed the attempted robbery, correct?
That's correct. He was on bond for a misdemeanor offense that later was charged as the felony possession. So that is the reason for the Willoughby Municipal Court's revocation of his bond. Thank you.
So where is the sober living at?
It's located in Cleveland Heights.
It's separate and apart from this Surgeon Health?
I think that they run the sober living home. A Surgeon Health does specifically. I don't know of the specific address if it's this.
I don't care about that. I mean, but if I were to order it and say that he's the reside at the sober living operated by
A
Surgeon Health?
Yes, Your Honor, that'd be correct.
Does the state have a position on this motion to modify bond?
Your Honor, Ms. Linden indicated that she would leave that to the court's discretion. If the court would like me to give some background on his criminal history, I know you were made aware of it in chambers. I can do so for the record as well.
That's okay. I mean, you did make me aware of his history, which appears to be significant in chambers. My concern with this, Mr. Umholtz, is that you were on bond, you were given a bond when the second charge occurred. I'll grant the motion and reset your bond and own recognizance with the condition that you attend PH partial hospitalization program through a Surgeon Health and reside in their sober living residence. If you mess this up, do something else, that's not going to be good, I'll tell you that.
He said if you mess this up or commit any other offense, that will not be good.
Yes, ma'am.
You understand that?
Yes, Your Honor. Thank you, Your Honor.
Now, you're going to have to find a way back here to the probation department for your interviews and assessments. We've ordered several evaluations that your attorney has requested for you. So it's going to take probably at least a couple different appointments where you're going to have to sit down with a doctor and be interviewed and take some tests. So you're going to have to appear at those. You're going to have to appear at those appointments. You understand that?
Yes, Your Honor.
In order for these reports to be completed, those interviews with you have to take place. And without the interviews, probation department can't do these reports. And without a pre-sentence report and investigation, I can't even consider probation as an option. So you have to show up on time when scheduled at the probation department for these interviews. I'm not going to continue the sentencing to a later day to get the interviews done because they weren't done initially because you failed to just cooperate and appear. You understand that?
I understand.
Now, one of the conditions of your bond also is that you don't take any drugs while you're on bond. You have to submit urine screens if requested. They have to be they have to be negative. A positive screen will result in your bond being revoked and a warrant being issued for you. Understand that?
I do, Your Honor.
All right, so what's going to happen here is you're in custody right now. They're going to go back. They'll start to do whatever they need to do to discharge you. It'll take a little bit of time. I want you to stop at the probation department before you leave today. So you're going to get out of jail at some point here, probably in the next couple hours, I imagine. You need to go to the probation department and go up and fill some paperwork out and get your dates to come back.
Yes, Your Honor.
If for whatever reason that doesn't work out today, if you get out too late, they're not there, then you need to contact them first thing Wednesday morning. They won't be here tomorrow because it's a holiday. So for whatever reason, if it's too late in the day when you get out and they're not there, you need to contact them first thing Wednesday morning. Call. They're open at 8, so call them between 8 and 9 in the morning to find out when they want you in here.
Yes, Your Honor.
You understand that the owner cognizance bond, your attorney alluded to it, but You have the paperwork for that to give to him? We'll need one for each case.
I have it.
Oh, you already have it?
Felony 4 could be.
So this OR bond means you don't have to post any money. Your sign, your signature is your bond, but you have to appear at all future court dates. And if you fail to appear at any future court dates, which in this case would be the sentencing, which Stan, we probably could push back now. That's perfect, all right. What date? What time? All right, so your sentencing is going to be August 14th at 9:30 for both of these cases. If you fail to appear for that sentencing hearing, aside from obviously the ramifications your failing to appear could cause for this case, that's a separate felony charge you'd be prosecuted for. Get another additional 18 months on. So it's obviously important you show up at all future court dates. You understand that?
Yes, sir.
All right. And the condition of your bond is that you reside at this, you participate in this treatment program, that you reside at this sober living residence. If you stop going to this treatment facility, or if you don't reside at the sober living residence, you're in violation of your bond, and then it would be revoked and a warrant would be issued for you. You understand that?
Yes, sir.
All right. Ms. Cutts, is there anything else?
No, thank you, Your Honor.
Ms. Stringer?
Nothing further. Thank you.
All right.
All right, we are here present in case 22 CR 1405, excuse me, State of Ohio versus D'Angelo Archie. Mr. Archie is here in open court. He's representing himself in this matter as the court previously granted Mr. Archie's motion for self-representation. Standby counsel is present at this time, Mary Springer from the Lake County Public Defender's Office. State of Ohio is here represented by Assistant Prosecutors Emily Contour and Abigail Bell. Now, the court scheduled this for a pretrial hearing to address several motions that are outstanding, plus just to get Mr. Archie in court to find out whether he's in custody right now, so make sure that, and he is representing himself, to make sure he has an opportunity to address any issues that he wants to have addressed. Our trial is currently scheduled, I don't have the exact date off the top of my head, but I think about 3 weeks.
25th, Your Honor.
What is it?
The 25th.
July 25th, so 3 weeks from tomorrow. 3 weeks from tomorrow. So we need to address motions that are outstanding and any other issues that we want to address. And I'll probably schedule another one of these before the trial date as well, just to make sure before we get started. So let me pull up these motions. I'm going to try to do them in some order that would make some sense. All right, the first motion the court's going to address is a motion filed by Mr. Archie. It's a motion for reconsideration for plea deal. Now, Mr. Archie, I don't have anything, I can't order anyone to make any plea offers. I don't get involved in the plea negotiations. So I can't grant this. I can't say you can plead to this or not, but it's up to the prosecutor to decide what they're willing to offer and not offer. But I guess I'll address it to make sure the prosecutor is aware of, I guess, in a sense, your counteroffer in this case. Well, let's get on the record. I know we did this last time, but what was the offer made by the state of Ohio in this case?
Your Honor, at this time there has been no offer since March. We haven't extended any offers to Mr. Archie. There were previous plea deals between our
Before
office
he failed
and
to appear. Okay.
Correct.
So is there an offer the state is
At
extending?
this time, there is no offer.
So, Mr. Archie, apparently you had made an offer. I'm assuming that you are indicating you're willing to plead guilty to, and correct me if I'm wrong, I'm just reading your motion. Count 1, receiving stolen property. Count 2, you're willing to plead guilty to counts 1 and 2 if the state were to dismiss count 3.
Yes.
At least you were at the time you wrote this.
Yes.
You received this motion, or Ms. Contour?
I did, Your Honor.
Okay. What's the state's position on this at that time?
At this point, we are still not making a plea offer. Since it has been filed, I will speak to my supervisor, and as you've stated, I believe we'll have another hearing. And if anything changes, we can.
Well, I don't want to wait to the next hearing to address this. If it's something that I don't twist arms. I don't pressure anybody in regards to pleading in criminal cases. So, but if it's something that's going to get done, I want it to get done. We're not going to go forward with all these other stuff, and then the couple days before the trial, I won't accept it then. So if it's something you're going to do, I'd ask that you go back. Today may be bad with the holidays, but by the end of this week, you could talk with your supervisor and see if it's something they're interested in. Notify the court. We can notify Mr. Archie, or you can notify the standby counsel for that purpose also. So again, Mr. Archie, I can't order this.
Okay.
I can't grant that, but I've brought it up to facilitate, I guess, an exchange here. You heard what was just said. They're not willing to do it at this time, but she'll go back, talk to her supervisor. If that's something she's willing to do, then she'll notify us by the end of this week, and we'll notify you. All right, in that regard. The next motion I want to address I know you filed a motion. I'm having trouble finding it here right now for the drug testing. You want it retested. Give me 1 second. Mr. Archer, you filed a motion requesting that, quote, retest the drug instrument along with all available evidence. So how I interpret this is you're asking that the drugs that are the basis for the, you all right there? You caught up?
My yeah, chain kind of caught up in my chair.
Yeah,
That's
no
cool. It's cool. I got it.
You all right? You good?
Yeah, I'm good.
You're requesting that the substance that's the basis for the drug charge be retested.
Yes,
that
Your
what-
Honor.
The court is willing to do that, but it's not going to get done quickly. I mean, it's not going to be done by July 25th. If we do that, the trial's going to have to be continued. So I will grant that request if you. I know you've contacted the crime lab to see if
Yes,
that's
I
something
have.
they can do, because I was advised of that. And I'll order that they retest it, but it's nothing that's going to get done immediately.
May I speak when you get opportunity?
Yeah, right now is your opportunity. Go ahead.
I looked at the original testing. I was incarcerated December 18th. They tested it on the 20th. So I don't understand why it would take so long for them to retest it. And they turned it in within a matter of days.
I don't know
I
how
have
long it will
the-
take.
I have-
I don't
I've
know.
looked at
I
it.
mean, I'm not. I have nothing to do with the crime lab. They don't work for
Gotcha.
me. You know, they're in their own independent. Well, they're associated with the Lake County, obviously. I can't. The trial's what, 3 weeks away? I mean, could it be done by then? It could, I guess. But I can't make any assurances. I don't know. I have nothing to do with it.
Yeah, if it's all the way with you, I didn't want it to get pushed back. I was ready to go to trial July 11th. Now I'm seeing it's a deposition July 11th instead of a trial.
Right. That's the next thing.
And it seems like it's being held for the prosecutor for whatever reason. I guess they're waiting on the testimony of the lab reporter, which is Kimberly A. Gilson.
That's what the deposition is. The
I know.
motion to request for the deposition is for her testimony.
I understand.
She's apparently unavailable on the trial date of July.
But I also know I never waived the 90-day. I never waived my 90 days.
Well,
I never.
I know you haven't, but the trial date is currently scheduled within that 90 days.
I don't think it is. But
Well, I guarantee you it is, but if you
Okay.
want to file a motion to challenge it, you're more than welcome to. I'm not going to. We can address that if that issue comes up, but
Okay.
I can assure you that it is based on the
Well, I
law.
appreciate you
mean,
pulling me
times-
in.
Sorry?
I appreciate you pulling me in and looking forth over my motions.
I will assure you of this. If the trial was to be continued because of this testing, it's not getting continued for months. I mean, we're talking of pushing it back, at the most 4 weeks or so. Now, I understand you're in custody. Don't get me wrong. I'm not trying to minimize the fact that that's nothing. But a lot of people fear that if they waive their time or get something bunched back, they're going to be sitting there for months and months, and that's not going to happen. I want to get this case over with.
I do
Be
too.
honest with you.
I do too, Your Honor.
So,
I'm willing to plead today, right now, to counts 1 and 2. Right now. I think this case has been going on long enough. I've been incarcerated since December 18th. Here it
no,
is.
you haven't been incarcerated since December 18th.
Well,
you got out in March, and
I
you're
got
on the.
let out
you're-
March 6th.
Yeah.
I was out for a month.
Well, I don't know what you want in regards to this retesting done. I could look into seeing how long it'll take. I'm not going to sit here right now and tell you that this trial can't, if it's not going to cause the continuance of the trial.
Okay.
What do you want done?
I still want to retest it.
Okay. Well, if it gets retested, the trial could get pushed back, but again, it's not going to get pushed back months. It's going to get pushed back into August sometime, which is, right now it's July 25th, so August sometime is just, at the most a month. All right, and that's what you're willing to do that.
Yeah, if it's gonna help my case, yes I do. Yes,
Well,
I am.
I can't tell you it's going to help you. I don't know what the results are going to be.
Yeah, I understand.
All right,
Just look over that.
then I'll grant that request. What was, and I know there's no offer, what was the original, when this originally came about, how was it originally set up in terms of?
The original offer, Your Honor, was to counts 1 and 3, and then there was some back and forth between our office and Ms. Carroll before the first trial date. Some counter offers.
What is count 3?
Possession of cocaine.
That's the drug charge?
Correct.
And it's not the drug charge?
Yes, it is,
Oh,
but
okay.
I'm not willing to plead.
No, I know that. You're shaking your head like she was
Yeah.
saying something wrong. And
That was the way.
count 1 and 2 is receiving stolen property?
Correct.
And what's the nature of those charges in terms
They're
of
two separate specifically listed properties, Your Honor.
2 separate pieces of,
Correct.
that he was in allegedly, you're alleging he was in possession of?
Yes, Your Honor.
And then what's the drug involved, allegedly in drug?
Cocaine.
Cocaine. And those are
All F5s.
All F5s, okay. There was a motion that was filed, you termed it motion for standby counsel for trial. Well, this court did already appoint standby counsel for trial. At the time we were here last, when I granted your motion to represent yourself, I appointed Ms. Carroll to be standby counsel. So I've done that. Now you have to make a decision, Mr. Archie, whether you want Ms. Carroll to be sitting at the trial table with you and introduced as your standby counsel, or just sitting in the back of the courtroom like behind you in one of the benches there. And that'll be a decision that you let me know. You can let me know the morning of trial about that. But that motion, you already have standby counsel appointed. I'm not changing the attorney who was appointed by this court as standby counsel. But that motion's already, it's moot because it's already been basically granted. You understand? You have any questions
Yeah.
about that?
Yeah, I understand, Your Honor, but also know the fact that due to I'm looking all these cases up. This is Ohio Revised Code case law. I have the right to adequate counsel, even if it's his assistant counsel. I just don't understand how you can assign somebody that I originally filed a motion to get rid of. I asked for the facts.
I get motions all the time from people that want to get rid of their appointed counsel. That doesn't mean they're entitled to get rid of their appointed counsel.
I understand but I also gave you reasons why. I didn't just.
I understand that, and everybody else always gives reasons why. You have the right to have counsel appointed for you free of charge. You don't get to handpick your attorney.
I'm not
that's
handpicking
going
anybody.
to-
I'm just asking for somebody different, Your Honor.
Ms. Carroll is a very qualified attorney.
Yeah, but it's always conflict of interest.
No, there's no conflicts of
Yes,
interest
it
that have been
is. I
presented
just
to
told you
this
this woman
court.
didn't do her job
So-
adequately.
I am.
Inadequate.
If your request is specifically asking for a different attorney to be appointed as standby counsel, that request is being denied.
Okay.
And I presume that's probably what you're really asking for. Is that correct?
Pretty much.
Well, because you know I did appoint standby counsel, correct?
Yeah, I did.
Ms. Carroll. You're requesting somebody else instead of Ms. Carroll. Does that make your request more accurate?
Yes, Your Honor.
All right. Well, I'm not going to request somebody else. I'm not going to order that somebody else serve as standby counsel. Ms. Carroll, again, is a qualified attorney. There's been nothing brought to this court's attention indicating any reason why she should be removed as attorney or standby attorney in this case. Your reasons that you set forth before are certainly noted for the record, but that request is denied. The last motion that was filed by the state of Ohio. It was a motion for to do the deposition testimony of Ms. Gilson. I will grant that if that's going to be necessary. Let me. What's Ms. Gilson's schedule like if the trial has to get continued for 3 or 4 weeks?
She's just out that week, Your Honor.
Okay.
She's back on the 29th of July.
Well, then obviously if the trial has to be moved, it would be moot.
Okay.
Or if you resolve this case, I'm not saying you are, it'll be moot. So I will hold off on ruling on, well, I'll let you, I'm telling you I will grant it if the trial is going forward on July 25th. And we'll do that then on July 11th as scheduled. But we'll decide that by the end of this week for certain. So, Mr. Archie, in regards to this deposition, are you familiar with what's going to be that entails?
I've asked around. I don't know exactly what's going to be asking me.
All right, well, I'm going to tell you right now that
Okay.
at this point, if the trial remains for July 25th,
Okay.
the court is permitting the testimony of Ms. Gilson to be presented by way of a prior video deposition, which means we're going to come into court here on July 11th, which is what, a week from today?
Okay.
A week from today, where Ms. Gilson will be here. She'll be testifying, just like if we were in trial. Prosecutor is going to ask questions. You're going to get the right to cross-examine Ms. Gilson. And this will be the testimony then that will be videotaped and preserved and presented to the jury at the trial on the 25th.
May I ask something? I'll have the right to cross-examine her at the deposition.
Yes. That's going to be that's the only time she won't be here for the trial.
Gotcha.
So next Monday, we will be having the hearing where she will be testifying, providing her testimony that will be presented to the trial. And at that time, you need to be prepared next Monday to cross-examine her. Now, by the end of this week, I'll let you know whether the trial is going forward on the 25th or not. If it's not, then that's going to be off, and you won't cross-examine her until the new trial date, and she'll be here live in person. But we'll decide. They're going to go back and talk to their supervisor about your offer, see if that's the way the case gets resolved. If not, we're going to find out about the timing of the retesting. If it gets pushed back to August, then that's not going to be an issue, and she'll be here for the trial.
Okay. May I say something?
But I just want to make sure you understand you need to be prepared. At least as of right now, you need to be prepared to cross-examine her next Monday.
Okay.
Okay, go ahead.
I want to state on the record that that's the reason why I asked her for Ashley Carolyn to be removed from my case, because when she originally brought forth the deal, it was for counts 1 and 2. That's what she told me. And in return, now this lady is saying they never offered 1 and 2. They offered 1 and 3. They told me to plead to any 2 of the 3. It's only 3 that I'm looking at. The other one is a misdemeanor. And it's saying, and I coming back with a re-offer, counter offer, as you may say. And I don't know what's going on, but that's what I'm stating on the record, that I'm willing to plead out to counts 1 and 2 if possible.
All right, well, that is noted for the record. You're aware of that, Ms. Contour. You'll go back and talk to whoever it is you need to chat with about that. Let us know as soon as possible. All right, I think that takes care of, at least as I'm aware of, all the outstanding motions. Ms. Contour, is there any other thing?
Your Honor, the only thing I would add for the record is I will go back and talk to Ms. Karen Shepard, and I will let the court know before Monday if you would entertain a change of plea on that date. But I will say that I did.
Well, I want to know by the end of this week.
Yes.
I mean, obviously you can't let me know today or tomorrow. We're off, but hopefully you can check and see on Wednesday or Thursday what the. I don't want to wait till Monday.
I think I will most definitely have an answer before the end of the week.
Okay.
But I did reach out to the crime lab, and I know Mr. Archie has as well, and they stated that hypothetically, it could take some time for testing because usually they have another lab do it with regards to their accreditation. So I know that they would be happy to talk to Mr. Archie about that process, but it will have to be sent out for testing. So I just wanted to make the court aware of that.
Why is that?
For accreditation purposes, the way that it's been explained to me, they said that it has to be sent to a private lab and that has to be facilitated by the defendant. If they were to send it to they say that an in-state lab that is run by the state will not take it in the state of Ohio. It has to be a private
Well,
lab.
I think Mr. Archie was. Correct me if I'm wrong. Maybe maybe it's not the way they do it. So you're aware that the crime lab originally tested the substance, right? And you have that lab report.
Mm-hmm.
Your request was that the same crime lab just retest it?
Because I don't truly believe that it was.
But you're asking that the people that originally tested it that said it was cocaine, you want them to be the same people that retest it?
I just asked.
Or you want a different...
It doesn't matter to me, Jan. I just want to make sure.
Well, I just don't know whether...
What's the cause of it?
No. I don't know whether an agency that's tested something and has already said this is what that substance is, you want them to retest it?
No, if they can find out another.
I think that's probably what Ms. Contour is saying, is that that's the way it's done.
Okay, I'm okay with
a
it.
different agency would have to retest it. It doesn't
Either way,
make sense for the same agency to
I'm
test
okay
it.
with it, Yana. Either way.
All right. Well, if you could, I want to find, you let me know how long they say that would take if a different agency has to do it.
Yes,
All
Your
right.
Honor.
Anything else?
Nothing further.
Mr. Archie, anything else?
No.
All right, we'll let you know at the end of the week what the status is.
All right. Thank you, Yana.
All right.